Your firm commissioned a sewer main servicing a Class 2 apartment development. The defects liability period has expired and you assume the commercial risk was closed. Then a letter of demand arrives from an owner's corporation, bypassing your contract entirely and alleging a breach of the statutory duty of care under Section 37 of the Design and Building Practitioners Act 2020. Here are 4 key points every New South Wales water contractor needs to understand. First, the statutory duty under Section 37 can reach civil contractors directly. If your pipeline or drainage works are physically connected to or service a Class 2 residential building, those works may constitute regulated construction work under Section 36. The duty is tortious, not contractual, which means subsequent owners with no commercial relationship to your firm can pursue you for economic loss years after practical completion. Second, your standard contractual defences are likely void against this claim. Section 40 of the DBP Act expressly provides that the statutory duty applies despite any contract to the contrary. Time bars and consequential loss exclusions in your subcontract are unenforceable to the extent they attempt to limit or exclude the statutory duty. Third, following the High Court's decision in Burn, proportionate liability cannot be relied upon to cap your exposure. The statutory duty operates as a non-delegable duty. If you seek to shift financial exposure to design engineers, certifiers or subcontractors, you must bring cross claims for contribution, and you bear the evidentiary and cost burden of proving their liability. Fourth, your liability window is fixed, but your regulatory risk is immediate. The absolute long stop limitation period is 10 years from completion. However, the New South Wales Building Commission can issue a building work rectification order that takes effect immediately upon service, stripping away your ability to run a protracted defence and forcing rectification at your cost while you pursue contribution through the courts. If you have received a letter of demand involving infrastructure connected to a Class 2 development, contact Merlo Law immediately to assess your statutory exposure and map your defence strategy early.